My name is Carolyne Kalson, and I've been handling unemployment appeals for over 20 years. A lot has changed over time. When I first started handling these appeals, almost all the hearings were done in Toms River in person. Now the hearings are done over the telephone, except in very unusual circumstances. I always say it's bad enough when you lose your job, but if you can't collect unemployment benefits, that is worse. You may not be able to survive economically during the lengthy appeals process. The appeals process can also be uphill. Unemployment has become more difficult to obtain over the years, which is a problem in a downward economy. The law has expanded, and we now have 3 types of misconduct, including severe misconduct. The problem with severe misconduct is that it is not clearly defined. Severe misconduct also carries a total disqualification of benefits. In the event of a termination, the issue for unemployment is always misconduct. The burden of proof is on the employer to establish misconduct, which generally is a willful violation of an employer rule. This begs the question, what are the rules of the employer? There are also times when there may be an issue between the employer and employee as to whether it was a quit or a termination. I've had hearings where the employee provided testimony at the initial stage, known as fact-finding, notwithstanding that it is the employer's burden to prove misconduct. The employee was disqualified based solely on their own testimony. This is clearly a violation of unemployment law and applications. The bad decisions tend to come from examiners who are not properly trained and generally have a bias in favor of employers. Therefore, I strongly recommend that all employees who are terminated consult with an attorney as soon as possible in the unemployment appeals process. In addition, you may also find that you have another employment-related case, as New Jersey is very protective of its employees. Unfortunately, many people call my office too late in the appeals process to provide any meaningful assistance. After fact-finding, the next step is the appeals tribunal hearing. At the hearing, we have the opportunity to present evidence and cross-examine witnesses. The next step is the Board of Review. The Board of Review is a paper appeal process. Unfortunately, the Board of Review tends to rubber stamp or approve the decisions of the appeal tribunal. The statistics have shown that employees that retain an attorney for the initial fact-finding hearing are successful 90% of the time. When you retain an attorney for your appeal tribunal hearing, you are successful 74 to 77% of the time. There is a lot at stake here. You really need to hire an attorney to ensure that your benefits are approved at the earliest level. Currently, there are 26 weeks of benefits available. If you lose at the lower level, you could be waiting months for an appeal and not have any necessary benefits coming in at that time. At the Board of Review, the success rate drops. If you retain an attorney, your chances of success are between 20 and 40%. Even if you may not win, your matter can be remanded for an additional hearing and testimony. The next level of appeal is to the Superior Court Appellate Division. Your chances of winning are slim. The appeal at that level is very complicated and requires an appellate-style brief and appendix. My office provides highly personal and professional service in all areas of labor and employment law, including unemployment appeals, harassment and discrimination, Family Medical Leave Act claims, workers' compensation, Social Security disability, and whistleblowing. We also handle severance negotiations and provide employment counseling both for employees and small employers. I welcome the opportunity to meet with you and discuss any of your concerns. Thank you for your time.